that his lectures and talks are widely received on the internet. He has also taught in the Andhra Pradesh Judicial Academy. 3 different bars and high courts have been fortunate enough to have a judge like Honorable Mr. Justice Naidu. He was a judge in the Andhra Pradesh High Court, then in Kerala High Court and Bombay High Court. He is a very popular judge, not only amongst the judges, lawyers, as well as the common people, because his judgments touch not only the issues which are for the common man. And then we thought that we could not have a better speaker to speak on the issue which not would only engage people, and therefore we thought, let's have the issue of common law principles and precedents. We have amongst us Honorable Mr. Justice Dama Seshadri Naidu. Welcome, sir. And before we ask him formally to speak, we have amongst us Bal K. Mehta, a former session judge, to formally welcome him. Mr. Bal K. Mehta, over to you to formally welcome Mr. Naidu. And we should all have the engaging session and insights of a sitting judge, which will benefit one and all. Over to you, Mr. Mehta.
Good afternoon. Am I audible?
It's audible. My
appropriate salutations to everybody in this webinar. It is my profound privilege to welcome Justice Seshadri Naidu to this session. About 2 months ago, when this lockdown was imposed upon entire of the country, one of the biggest threat was that layoff may arrest our faculties. Credit goes to Vikas Chatrat and Beyond Law that day in and day out he is holding such webinars, and the foremost challenge he has lived up to is to keep finding a very good faculty speaker one after the other. The challenge has always been what next, and he comes up with better and better options. Justice Naidu belongs to a town we all feel it is a holy city of Tirupati. Lordship started practice in district courts, both on civil and criminal sides, then to Hyderabad, and has been associated with Andhra Pradesh Judicial Academy, Hyderabad as a guest faculty. I share this privilege, having served Chandigarh Judicial Academy for 2 years as Director Administration. Justice Naidu was elevated to the High Court of Andhra Pradesh in the year 2013 and was sworn in as Judge of Kerala High Court on 30th of June 2014. And for the last about 1 year, he is adoring the coveted bench of Bombay High Court. Apart from numerous judgments on all walks of the life and having penned some very good books, Justice Naidu has to his credit a literary taste in his work. I came across one of his judgments in a rent matter delivered in Bombay High Court, where his lordship quoted Charles Dickens and came up with the quote that time machines in courts live on and litigation never ends. I'm very sure that the audience today would be richly benefited from experience, wisdom, and genius of Justice Naidu. Over to you, sir.
Justice Naidu,
Yes, please.
Yes, sir.
Good evening to all. Thank you, my friend Vikas Chetrat and Sri B.K. Mehta for the kind words. And initially I thought lockdown will give us boredom. Now I've realized it's giving us wisdom instead. Usually, lawyers love leisure, and with that, pleasure, of course, in a good sense. In a very stressful profession, they welcome any break. But this time, amazingly, across the nation, there's been a wave of webinars hosted and conducted by lawyer groups and associations. To their commendable credit, Beyond Law CLC and University Institute of Legal Studies, Punjab University, have been conducting webinars, as I've learned, almost daily. So far, they've had the lectures from a string of scholars and legal luminaries. I've been fortunate to be invited to be part of it, though I cannot bracket myself in the league of previous speakers. I thank the organizers, including my friend Vikas Chetrat and my elder brother, Justice Nagamurthy, for this opportunity. Now, coming to the topic, we talk of common law and civil law and criminal law, common law and equity, common law and statute law. But we are talking about common law contrasted with statute law today and its relationship or rivalry with the law of equity. You may appreciate every country has law. A country may be democratic, autocratic, or despotic, or in George Orwellian terms, perhaps dystopic. How do the countries or nations get law? Let's think of it. The first category, law is a historical development. That's why Justice Oliver Wendell Holmes Jr. has said in his seminal book, The Common Law, the life of the law has not been logic, it has been experience. He gives a historical perspective to it. For him, the law embodies the story of a nation's development through many centuries, and it cannot be dealt with as if it contained only the axioms and corollaries of a book of mathematics. Very importantly, he says, in order to know what it is, we must know what it has been and what it tends to become. We must alternately consult history and existing theories of legislation. And let's think of the second category. The law in some countries is an imposed intellectual regime, not an organic historical product. Then let's come to the third category. The combination of the two above, partly an organic growth, a historical perspective it will have, and partly imposed perhaps an alien ruler. And when it comes to Indian jurisprudence, it aptly demonstrates the third category. Today, we'll discuss the common law concept called case law, precedent, stare decisis. And in fact, for many people, common law is synonymous with case law or precedent. But common law is more, in fact, much more. The title advertised, or as Mr. Vikas Chetrat would prefer to call it, common law principles and precedents. True, the precedent is one of those principles. For paucity of time, we'll trace the historical origin of common law. We will examine the interplay between common law and equity. We will see how they have come to affect India. And then we will deal with different concepts of precedents. I reckon our focus will be more on precedents, the darling of every aspiring lawyer. We mostly measure a lawyer's intellectual prowess with the catalogs of case law he can recite. I too had that notion when I was on the other side of the divide, the bar. Now I have my reservations. I reckon case law kills the lawyer's creativity. It doesn't allow him or her to look at the problem from a different perspective. Lord Alfred Tennyson views precedent once in the positive light and at another instance in the negative light. I'll just quote both of them. A land of settled government, a land of just and old renown, where freedom slowly broadens down from precedent to precedent. That's what he said positively in one instance. Let me come to the other one. The same poet has said, mastering the lawless science of our law, that codeless myriad of precedent, that wilderness of single instances. Well, to know the law, we should know the country, its culture, its moral philosophy. I'll illustrate what happens otherwise. Friends, once an anthropologist had gone over to an Amazon tribe in South America. He lived with them for 14 years. The tribe away from civilization, at least in terms of what we call civilization. He wanted to reform them. So staying with them 14 long years, he narrates in his book one incident of how the culture affects the moral perspective or our interpretative ability of any issue. Then he asks all of them to assemble. He narrates the story of Hamlet as dramatized by Shakespeare. He tells them there used to be a very benevolent king, Hamlet, in Denmark. His brother, younger brother, was scheming. One day, in the royal garden when the king was asleep, his brother stealthily sneaked in, poured poison in his ear and killed him. Later, he appropriated the kingdom, usurped it, and incestuously married his brother's wife. And also, he tried to kill his brother's son, his nephew. And he said, you see how morally repugnant that man was. Immediately, the chief stood up and shot back. Said, what's wrong in it? I don't see anything wrong as far as the younger brother is concerned. This time, it's the turn of the professor to be surprised. When he asked how, that man said, a king should always be wary, vigilant. And here, perhaps this king wasn't that vigilant. He paid a heavy price for that one. A man who is cunning and who has the ability to strike the enemy at the most opportune time could as well become the king. So the younger brother became the king. Whatever the property of the previous king should belong to the present king. And women too are property. That's why he married his brother's wife. And about the killing of the son, he said, no fool will have an enemy living, more so if he's a king. That's what the younger brother of the king has tried to do. And that's how the moral perspective changes from culture to culture. That's why when we talk about the common law, we'd better think of the nation very briefly, though, that has given us this law. And if you want to have an official title for the country, it's a mouthful, the United Kingdom of Great Britain and Northern Ireland. And you know, even before Christ, there was no country like England or UK or Great Britain, whatever. It was mostly principalities of various tribes. The Romans ruled for many centuries. And by then, there was neither an English people or English language. There was no nationhood either. Then came the Vikings, the Crusaders. Even by then, there was no single nation. It was so until 1066, the year that divides British history. That was the year of Norman invasion. That was the year that heralded common law, not immediately though. William the Conqueror, the Norman king, coming from northern part of France, won the Battle of Hastings in 1066. Until then, there was no uniform legal system. All the provinces or counties had the local laws, if we can call them so. They are based on essentially custom. But William the Conqueror realized that he could control the people more effectively if he could impose law common to all the people. So William the Conqueror was the founder, technically speaking, of the common law. He set up what we could call curia regis, that is the king's court, and appointed his own judges. They are not trained judges. They are more like priests administering canonical law with a Roman flavor. If we want to call somebody the father of common law truly, it must be Henry II, who ruled in the 12th century, that's from 1154 to 1189. During his reign, the king appointed judges who sat a couple of days in London at the Westminster. The rest of the days, these king-appointed judges were touring the provinces or counties. Each judge would go around. He circuits an area. So circuit courts have come to exist. That was the way justice was administered. You may realize, even when the American Constitution was created, the Federal Supreme Court in 1787, it had not fixed seat of hearing. It had no fixed seat of hearing. The judges were going in circuits. In fact, many died in a vast country, going about months on end to administer justice without having a fixed seat. So time came when nobody accepted the judgeship of American Federal Supreme Court. And finally, American Supreme Court, the American Constitution doesn't require a law degree to be appointed as an American judge, Supreme Court judge especially. The greatest of all, Chief Justice Marshall, did not complete his law. Coming back to the origins of common law, Henry II introduced many legal remedies. And these remedies have impinged on the rudimentary local courts which administer justice based on the tradition or the custom of that area, and also ecclesiastical courts, essentially church-based, canonical. But the king persisted and the complexity grew. So people preferred royal justice to provincial dispensation or canonical adjudication. The circuit judges came back to Westminster after their circuits and exchanged their notes.
Justice Naidu, could you just come slightly closer to the mic because some people are saying you're not audible.
Oh, that's it. I'm using my AirPod so that I thought it could be uncumbersome. Am I audible? Should I change that to the?
Sir, I'm just asking. Could everybody post it on the chat box regarding the audibility? Not, sir, try for a minute. We will come to know. Yes,
yes,
sir.
Indeed. Should I go on?
Yeah, now it's better.
Yeah, thank you. Whenever it's not audible, let me know. I can shift over to the other mode of
no, it's okay.
Audio device. Yes.
No, it's much better.
Yes, yes. As we were talking about the circuit judges appointed by Henry II, and they were going about administering justice in various counties. Besides, they're sitting a day or two in Westminster. As the complexity grew, these people, the judges, the so-called judges then, whenever they met in Westminster, they discussed with fellow judges their experience in other counties, and they exchanged notes. Then, again and again, when they have gone over to some other county and faced the same problem, they have started applying whatever they've applied earlier. So that's how they preserved their notes. And that preserved notes became the precedent. Later down the line, one Mr. Henry Bracton, a judge's clerk, compiled all the decisions. And that has come out to be the yearbook, perhaps the first reported law journal. He also became a judge later. That's a different story. Now, England or Britain or the UK, whatever the name you call that with, had been for the first time consolidated as a nation with an identity thanks to the Norman invasion. And we have talked about that part. Then, by the time the Normans invaded, there wasn't a language called English. There had been many dialects, Celtic, Germanic, English, Saxonic, and all those things. But by then, the official language was Latin. And when these invaders from French part of the world came, they introduced the peculiar dialect of French, which later came to be called as Law French. Then, first, the official language was Latin. With the king, the Norman invasion, Law French was introduced. But the common people were speaking either English, Saxon, or other local dialects from the Germanic tribes. So this part of the country has had three languages to be practiced or enforced. That is, the church went on with Latin. The rulers and the aristocratic people confined to Law French, and that's the genteel language, as they called it. The proletariat, the common people, they spoke the local dialect. What was the language practiced? For many, many centuries, it was the French, the Law French that was there. That's why the legal language has a peculiarity of assimilating three languages by the time it came to India. We have had our Latin maxims, and we have doublets and triplets combining all these languages. For example, you take aid and abet, null and void, part and parcel, give and grant, keep and maintain, cease and desist. If you think of triplets, build, erect, or construct, costs, charges and expenses, place, install or affix, rest, residue and remainder, give, devise and bequeath. All these things do indicate, in fact, they convey the same idea, but having more than one expression needed. So that's why we have been accused of being at times very, roundabout and prolix. There is one very good book on this conveyancing or drafting by Dr. Harugopal. It's in 2 volumes. At the very beginning, he narrates an interesting event about the Indian style of advocacy. He says, the Indian populace, as a matter of practice, first go to untrained people, the traditional draftsmen waiting at the registrar's office or somewhere, and get all the documents drafted. When a problem arises, they come to the lawyer in the end, not the other way around. That's why he says, thanks to the anarchistic documentary writing by the traditional people, not the lawyers have been making their living. Now let me come back to common law. Friends, when the common law has been applied across the board in preference to the customary law or canonical law, over the time, these judges have become quite monotonous or mechanical. They've almost become automats. Today they go to a province called Kent, let me say. They face a problem. They adjudicate and decide. And the next week they go to Middlesex or Essex. And there they have a problem which they feel similar. Straight away, they remember what they have decided on an earlier occasion. They take out that particular decision from their armory and they say that, yes, we have already decided, and that applies to you here also on all fours. So that's how they have started administering the justice in the name of the decided cases. But many people have been dissatisfied. They have argued before the common law judges that their case stands on a different footing. It can't be viewed as was the case they decided earlier. But the judges perhaps persisted. So they started petitioning the king. Look, your judges have been deciding cases rather mechanically. They have not paid attention to the nuances that I have presented to them. I have been put to prejudice because of that. Please render me justice. That is the petition. Then he has started referring all of them to the chancellor, who was both a lawyer and a priest, and said to be the king's conscience keeper. The chancellor started deciding the cases which have been referred to by the king from the clients who have not been satisfied with the dispensation under the common. The chancellor followed the principles of natural justice and fairness. He disregarded the precedent. So, first, in the absence of any statute from the Norman period, the king's appointed judges rendered justice which is common for the country. That's how it has become common. But the common law has had its inbuilt deficiencies, and that has given rise to dissatisfaction. Then people petition, and that has led to another division called equity or chancery division. That's how two streams of justice have come to prevail under the common law. Then, if you see how the common law could not meet the requirements, let me tell an instance. Under common law, the recognized mode of remedy is compensation. Suppose there is an agreement of sale. In the meanwhile, the prices get jacked up. So the owner doesn't intend to sell it. By the time, let's say that it's risen 5 or 6 times. So he says that, now I don't want to perform my part of the contract. The other person, the prospective purchaser, goes to the court, and court simply says, pay the compensation. And this owner, who has been richer 5 or 6 times, is more than willing to pay the compensation. And this is where the law has been literally applied by the common court. But dissatisfied when this litigant has gone to the king and then to the chancellor, they've invented this equity jurisprudence of specific performance. You may kindly remember, this equity is not a complete system of law. It merely filled the gaps in the common law and softened the strict rules of common law. Thus, equity maxims have developed. You have been familiar. Equity looks to the intention and not the form. He who comes to equity must come with clean hands. Delay defeats equity. Equity will not suffer wrong to be without a remedy. When it comes to the last aspect, let's think of one case I've dealt with about a couple of years ago. One person applied for a government job. He could not get it. He filed a writ petition. For that post, the maximum age was, maximum age was about 26 years. By the time he tried and denied, he was about 25. And he contended before the court that though he was qualified in every respect, the selecting authorities wrongfully denied him a chance of having government employment. The case had been pending for about 5 years. By the time it came for hearing, the age prescribed was, as I said, 26 years. By the time he applied and he came before the court, he was 25. By the time the case came up for hearing, he was 30. Then the government argued in one case called Sunil Matthew versus Union of India in Kerala High Court, decided in 2017, that either way, now court can't force the government, that's the argument. Court can't force the government to appoint him because now he's already been barred by the age. In that context, the court has applied an equity principle called non pro tunc, NUNC, This doctrine says, now for then, a suitor comes, a litigant comes to the court for an instantaneous remedy. For various logistical reasons, practical problems, court cannot render instantaneous justice. The matter takes time. So in the meanwhile, if that party earns any disability, that should not come in the way. That's what this doctrine is. I've said, since he filed the case when he was at 25, and the judgment should be treated as if it were decided on the day he filed it. So that doctrine of relation back, if applied, he is qualified, he should be given the job. It's one simple instance of how equity comes and trumps over the literal application of law. Another very important and emerging and ever emerging, may I say, branch of law of equity, which fills the gaps left gaping by common law, is the injunctions. Traditionally, we speak of prohibitory and mandatory injunctions, interim and perpetual injunctions. But let me deal with a couple of instances how the judicial imagination has expanded and inventive it has become, so that to have different remedies, because you know pretty well that you buy just, I buy remedium. If I have a problem, there should be a remedy for that one. We have known about Mareva injunction, which was applied for the first time in 1975. It's nothing but in our usual terms called attachment before judgment or freezing of assets. It's one aspect of equity jurisdiction. Then ante-suit injunction. And in the area of conflict of laws, this ante-suit injunction is an order issued by a court or arbitral tribunal that prevents an opposing party from commencing or continuing a proceeding in another jurisdiction or forum. It's nothing but forum hunting. Then you have quietimate injunction. That's nothing but prohibitory injunction. In anticipation, seeking an injunction. You've got Bayer injunction, B-A-Y-E-R. All these injunctions get their name from the cases that have been decided for the first time. This Bayer injunction was in 1986. It's about restraining a party, especially a judgment debtor, not to leave the jurisdiction. Then Anton Pillar injunction, that was in 1976. And it's about search orders. And now, let me come to an important aspect that's been the case in the last 15, 20 years. India also has been applying that quite frequently. John Doe injunction. You know, John Doe means an unnamed person, like Roe versus Wade. Roe is a pseudonym. It's not a party's name. Since a pregnant woman has fought for right to abortion, courts have felt that her name should not be revealed. That's why they have given her a pseudonym called Roe. Similarly, this John Doe. In Indian terminology, you can call it Ashok Kumar injunction. It's a sort of an injunction given against an anonymous person. You take the example of section 148A of CPC. When you want to file any caveat, you should have known the opponent. In one instance in Karnataka, a petitioner, rather the plaintiff, filed an injunction against unknown persons. That was rejected. His contention was this: Whenever I name a couple of persons saying that they have been trying to trespass upon my property, they are trying to knock away the property, the opponents will wait, they will avoid these two persons, and they will bring in some other person's name and get an injunction behind the back. So he wanted the injunction vis-a-vis the property rather than the person. But that was referred to a division bench. Later, I reckon a full bench. They have held injunctions are in personam. That's why they can't be an injunction and rem in the sense across the board against the world. They've refused. But this John Doe injunction recognizes that. As far as India is concerned, in 2002, Delhi High Court for the first time has applied it. That's in Tej Television versus Rajan Mandal. And you may appreciate most of the times when it comes to film industry, this piracy, online copying, there's no way of anybody knowing who is going to do that one. So this John Doe injunction is applied. So it's given without the name and it applies to whoever violates it. So the service providers will be bound by the action and they take down any such uploading which is illegal. Now let me come to another species of injunction. I'd like to underline, law is not static. It's not a dead letter. And the remedies are not frozen or fossilized. A judicial invention and imagination can have any sort of remedy, and the latest in the armory of injunctions as a facet of this equity is super injunction. It's a sort of a gag order. Let's take for an example, a celebrity has a scandalous litigation, maybe involving his family or something else. And most of the times, by the time the case is over, he may come out unscathed, innocent, whatever. But the sleaze, the sellability of celebrities' personal lives may cause incalculable damage to his reputation. So such people can apply for this super injunction. The specialty of this is, suppose I direct that so-and-so case is pending and nobody should report about its developments. It's an injunction. But any person can write about this injunction saying, since there is an injunction, I'm not reporting about so-and-so. That is enough for the people to know. To avoid that, even that instance that there is an injunction also should not be reported. It's something like a black hole injunction, sucking everything in. Friends, now to look back, we have begun our discussion with how the common law has originated. How it's been applied across the country commonly, that's how it has come to be called a common law. How it has had its inadequacies because of the blind following of the precedent, our past decisions without any reference to the nuances of an individual case presented. And that dissatisfaction has led to the emergence of equity. And equity to this day has been flourishing. And it's an emerging and ever-evolving field. And we have had all sorts of distinctions that have been there. So in England, in the formative years, whoever is dissatisfied with common law dispensation, he started going to equity court. So they have started issuing cross writs. So the litigation got stuck and it has led to sort of a chaos. Eventually, there came a direction that equity should prevail over the common law. But how about India? Incidentally and historically, by the time the English brought in their common law, it has come to us bundled along with equity. That's why we don't distinguish between equity and common law. Technically speaking, we have treated them together. And in the absence of statute, they do play a role. Even in the presence of statute, they fill the gaps, the interstices that have left unvaried or that could not be filled up envision these two branches will take care. Now let me come to the precedent. I began the session by saying we reckon the intellect of any advocate with the number of case law he could belt out or remember. And I've also added a caveat to that one: case law kills creativity. I'll demonstrate how it happens. Most of you may remember about 25 years ago, there was a Supreme Court judgment in a matrimonial dispute that concerned a divorce application filed by the husband. He pleaded that as a specific instance of mental cruelty, one day he invited his friends home. In their presence, the wife flew into a rage, abused him, snapped her thali, that means Mangal Sutra, thali, the sacred thread around Indian women's neck, and he threw it on his face. The Supreme Court has ruled that amounted to mental cruelty. Lo and behold, my friends, next 20 years, almost every divorce case filed by husband contained this incident. This is what President does to us. This is a sort of a confirmation bias if you think cognitively. That means you're being focused on your case. And whenever you look for case law, you've always been made up in the sense that you try to find a point positivity. So even when that's not been matching your requirement, still we persist that that must be the precedent. And unless we play the devil's advocacy, we may not have that objective look to see whether a precedent is really useful for us or not. So I believe it's a prop as a last resort, not to begin with. Now let me tell what is meant by a precedent. As I've told, common law is equated with precedent law or case law. So what is meant by precedent? Precedere, what follows before. Before, cedere, that's followed. So here we have had a Latin maxim called stare decisis et non quaita movere. It is shortened as stare decisis and loosely translated, stand by what has been decided and do not unsettle the established. Of course, there is another saying, stare rationibus decidendi, keep the reasoning of the past case. My friends, you may kindly appreciate this particular aspect is not correct. Perhaps stare decisis is right in the shortened form. What is being decided should stand, but not the ratio of what has been decided. In the words of Rogero Aldacet, the judge of the Third Circuit Court, sometimes he's a specialist on presidential law. He has written a couple of books. You can as well Google some of the finest articles written by this judge. He says sometimes the discussion overruns the decision. So the reasoning is not the safe guide. And many of us may be wondering how come we always talk about ratio decidendi, the ratio of the decision rather than the decision itself. And this proposition is contrary to that one. I'll come to that and I'll demonstrate how this is otherwise. So he says, this Aldacet says, what the judge did, not what he said, matters when it comes to precedent. In other words, strictly, the court is not bound by the statement of reason or this dictis set forth in the rationale. Let me see how, through the ages, this concept of precedent has been appreciated in common law world. Who else should I start with other than William Blackstone? He says, stare decisis, keep the scales of justice even and steady. Then let me talk about Alexander Hamilton. In his Federalist paper, number 78, he says, a robust respect for precedent is indispensable to preventing judges from exercising arbitrary discretion. In one case, the American Supreme Court has said, precedent is a foundation stone of rule of law. Then, why the confusion? Many precedents, thick and fast, every day coming and confusing us. It's inevitable. You may appreciate in some jurisdictions, the judges sit en-banked, E-N-B-A-N-C. En-bank means, the best example is American Supreme Court. All the 9 judges sit together. So this is called en-bank sitting. There won't be any much confusion about the case law because the whole court, sitting single, has been conscious about its past decisions and it tries to modulate. But in other jurisdictions, precisely Indian jurisdiction, if you take, the Supreme Court and the High Courts sit in panels. So if you think of Supreme Court, say roughly 16 benches, that means technically there are 16 Supreme Courts. So sometimes, because law is highly subjective, the same day you may have decisions which are diametrically opposite. Then, what is the role of precedent in the face of a statute? Earlier, common law was independent and was rivaling the statute law. In fact, statute law was the later rival. Now, all the common law that's been doing is to be an aid in the interpretation of statutes law. To be precise, even in the UK, statutes are swallowing up the common law. Very recently, that was in 2019, Andrew Burrows, the Oxford professor, who is going to be the UK Supreme Court judge from June 2020 onwards, in his Hamlin lecture titled Think About Statutes, talks about the role of common law in interpretation and also in the face of statute law, how it survives. According to him, in the courts interpreting statute law, the president acts as the beneficial hindsight. He feels statute law can never completely replace the common law or precedent. It always remains there to fill the gaps, to take care of interstitial treatises. Let's remember, the purpose of law is to settle disputes finally, but not to decide correctly or rightly. I may say, predictability is its virtue, not infallibility. Now, if we can think of how we have precedents, in what way we tend to understand them, how we apply them to various fact situations. There are, as the scholars have recognized, 4 models. The first one is the textbook common law model. That is, it considers only the adjudicative facts. The second model is adjudicative facts plus facts not on record. In a sense, it borders on mixing the law with equity. Then the third variety is based on broad array of facts, for example, batch cases, where the individual differences have been sunk and only the broad parameters have been taken. And then if you take the fourth category, a decision as a general principle of law, for example, Vishaka versus State of Rajasthan. Friends, the application of precedent has been consecrated constitutionally under Article 141. And before I touch upon that aspect, let me remind you, precedent applies both horizontally and vertically. Verticality means a single judge is bound by the division bench by the full bench, and full bench by the larger bench, high courts by the Supreme Court, other subordinate courts by the High Court. This is verticality. Horizontality, a single judge judgment binds another learned single judge. A division bench judgment binds another division bench This is horizontality. When it comes to anything that's been declared as to be overruled, rather, there is some delicacy. What's been declared as per incurium, in verticality, courts will not take the liberty of declaring easily anything per incurium. Even a judge has been convinced that the bench of higher strength or superior strength has missed on a patent statutory aspect or a previous binding decision. The wisdom demands, or the judicial propriety as we call it, demands that it be referred to a larger bench. But among the horizontality, yes, we tend to take liberties and we say that the learned judge of co-equal strength has missed on so and so aspect, that's why it may not. Now, kindly have a look at Article 141. It reads, if I could, law declared by Supreme Court to be binding on all courts. You may kindly see that, law declared by Supreme Court to be binding on all courts. And you may kindly think of it, whether the decision by the Supreme Court, does it bind the Supreme Court itself, is the question I may pose unto myself. And there have been any number of judgments, and I'm pretty much conscious that I'm bound by precedent. At the same time, having said that, let me remind you, in a seminar, in a discussion, we will have the intellectual freedom. We may discuss things which are contrary to established law. It's only to invite further discussion and enlightenment on that aspect. It does not mean that we have disregarded any precedent. So, you know pretty well that courts have repeatedly said, the Supreme Court, that under 141, Article 141, the decision by the Supreme Court does not bind itself, but judicial propriety demands it should be bound unless under exceptional circumstances it has to be violated, if at all. But kindly see the sentence that's been, what I've read a while ago, law declared by Supreme Court to be binding on all courts. All courts, not all other courts. There's no other there. All courts include Supreme Court because Supreme Court sits in panel, not en banc. There lies the catch, I believe. It may require further probe. For this reason, when it comes to American Supreme Court, when all 9 judges sit together en banc and they decide if this precedent applies to them, there'll be stultification of law. They can't go beyond. They can't correct the historical errors. That's why they have declared the law could not be applied with that vigor. The stare decisis could not be applied with the same vigor. So was the case with House of Lords too. We'll come to that a little later. Now, many people have had the concept whether a precedent is prospective or retrospective. A statute may be prospective, a statute may be retrospective. Again, we may think of, if it's an adjective law, there is a presumption that that's always retrospective. If it's substantive law, there is again a presumption that it is prospective unless it's been specified. But that retrospectivity or prospectivity does not apply to the case law or the precedent, because courts do not invent or legislate on any legal aspect. They only declare what has been there all along in the statute. So this concept of retrospectivity or prospectivity does not apply. So we have to take that law has always been, as it has been declared by the court in the name of precedent, means as if from the beginning. Then it spells disaster in certain cases where a particular legal aspect may have been holding the field for quite considerable time. After that, courts may have felt that that was wrongly decided. For that to overcome, the courts have invented this prospective overruling. And you know the celebrated case of Golaknath, where this particular principle has been applied in India for the first time. You know, traditionally, a judicial declaration that a law is unconstitutional is deemed effective prospectively as well as retrospectively. An unconstitutional law is regarded to have been void from its very inception. The theory is that the judge does not make law, but discovers or finds true law. Therefore, when a court decision changes the earlier law, then this law should be regarded not as new, but as having been there all the time, which the court has now discovered. Thus, the law as now found by the court must apply to the past as well as the future transactions. As against this view, the US Supreme Court has developed the doctrine of prospective overruling, which we have adopted in Golaknath. But Golaknath has applied that very differently. If you compare these two jurisdictions, you may realize in the USA, the theory of prospective overruling has been applied to hold the impugned law invalid from the date of the decision and not earlier. But in Golaknath, all the constitutional amendments were said to remain valid forever, even after the Supreme Court decision in Golaknath. Only the principle of non-amendability of the fundamental right was held to be applied in future. Here you can see the catch. Under the American jurisdiction or doctrine, from then onwards, prospectively, it's been invalidated. Here, all the laws, all the constitutional amendments, though were held to be unconstitutional, they were saved even prospectively. It is a very innovative approach Supreme Court has adopted, given the importance of agrarian reforms. Until then, most of the amendments related to agrarian reforms. And in Indusahani's case, that's Mandal case, the Supreme Court has gone one step ahead in applying the prospective overruling, and they have held whatever been declared in that one as ultra vires or unconstitutional should hold the field for next 5 years to come, notwithstanding their invalidity. So as something has been declared invalid, but it was saved for next 5 years to come. And if we revisit Golaknath, it has had certain inbuilt safeguards put if at all the courts have to apply the prospective overruling. It is said that the doctrine should be used for the timing only in constitutional matters. It should be applied only by the Supreme Court and no other court. Then, to be mounted in accordance with the justice and cause or matter before it. But you could see down the line, it's been applied in various settings. For example, Gita Hariharan versus RBI. It has applied vis-a-vis a statutory provision, that's Section 60A of the Hindu Minority and Guardianship Act. And you could have seen another case, India Cement case, where a statute has been declared unconstitutional as a taxing provision, but government was saved from repaying the amount. And again, there are any number of cases where courts have applied that in different contexts. But the most striking aspect or often encountered aspect of prospective overruling these days is with regard to college admissions. Because by the time the cases are decided in the courts, many students may have joined the course, may have completed that or in the process of completing. That's why they have said that it will not revisit what's been already done. Now let me come to how the court faces the problem in applying the precedents. As a lawyer, you may feel my case is open and shut case. I have established the facts. I've had evidence to clinch my case, and also I have a couple of precedents. Then why the court dithers on it? The court drags its feet, as you could call it, on deciding in my favor. I'll tell what weighs in the mind of the judge in applying any precedent. Recently, last year, or in the beginning of this year, you must have heard about a case called the Kerala building case. You know what happened in Cochin? When I was there, a builder has raised some high-rise blocks of buildings in violation of CRZ regulations. Then somebody questioned that one. When the case was pending, the government amended the law, regularized them. In that context, the High Court has held, now whatever the defect that stood cured, but still the matter went to the Supreme Court. Supreme Court said when they built, it was in violation, and the subsequent change, if any, could not alter the position. So it must go. Then about 5 blocks have come down. You take another example. I'll tell the importance of this one. Let's take another example. That's Vyapam case, that so-called medical scam case. In that one, the court has found that there were irregularities in medical admission, and that has led to litigation. By the time it reached Supreme Court, many of the students who joined, either rightly or wrongly, by whatever means, fair or foul, have completed and had their medical degrees. So the Supreme Court, a 2-judge bench, caught on the horns of the dilemma whether those degrees should be saved, whether those doctors should be allowed to practice. Because in the first place, court has declared that the process was vitiated. Now by then, these people had their undergraduation, their degrees. One learned judge has held, yes, it's a national waste to undo the whole thing. So let them have their degrees, but they should give a bond that they should work in the rural areas for a fixed number of years to redeem themselves. Another learned judge has held, it's a poisonous fruit. They've obtained that in a fraudulent way, it should go. And it's been referred to a 3-judge bench, and 3-judge bench eventually held as a remember that those degrees have been invalidated. You know here, what is the approach the court has adapted? If you read any standard book on legal reasoning, there are 2 ways to decide a case. That's called ex post perspective and ex ante perspective. You know what's meant by ex post perspective? I rather, in the lighter vein, say advocates always think ex post perfective. They come to the court, they say, this is what has happened, you please give me the remedy. They talk about the past and they want a remedy to compensate in the best manner possible about what has happened in the past. Ex ante perspective is something has happened. If I interfere at this stage, what should be the impact of this decision in future cases? See, for example, in Kerala building case, court has taken ex ante perspective. So it has put its foot down and said, once there is a violation, the later curing of it is of no consequence, it should go. Otherwise, everybody takes liberty in the hope that one day the law will be changed or it will be regularized. They keep on with impunity violating the law. And you take Vyapam case, there again the court has adopted the same approach. So the court faces this problem of applying the law only when it thinks of whether it will have its impact on future, more so either the High Court or the Supreme Court being a court of record. And there have been any number of judgments which can think of. Sometimes somebody loses and it really appears unethical to deny him a chance, but courts would be thinking of what could be the consequences. I'll tell one classic case and move on to the other aspects so that we could wrap it up within the time that's been allotted, so that we can have at least half an hour for our discussion, because I strongly believe this precedent is a matter to be discussed rather than to be listened to. See, for example, in one case, Illinois Supreme Court has decided in a bank, a masked person came with a gun, kept a person, a nearby customer, at the gunpoint and told this teller to pay the money. The teller was frozen with fear. He did not react. Again, this masked man threatened, warned. Still, that man did not move. So the masterman carried the threat. He killed the person, the customer, and he left. Then the dependents of the person who died, the customer, sued the bank for compensation. You know, in any bank, the amount kept is insured. Had the teller or the cashier paid the amount, the bank wouldn't have suffered any loss because it would have been paid out of this insured amount. But they haven't done that one. When the legal representatives sued for compensation, saying that their breadwinner has been lost and they've had no succor, but the court held no, the bank is not required to pay. Here, the court has applied ex ante approach, because once you take the classic example of hijacking across the world, the nations have taken a policy decision not to yield to the demand because it gives to, if at all they have this ex post perspective, whatever has happened, that should be remedied. No, that spells disaster. So is the case in adjudication also. Yes, I've had a handful of case law on that aspect, but given the time, I reckon I have to skip that one. Now let me come to a couple of aspects of how the precedent is to be gathered. Mr. Chetrat?
Yes, sir.
Do I have time or should I wrap it up? Which way should I go?
So once we are hearing you seamlessly and it's going with the connectivity, I think we should go with the flow. We can have the Q&A. That's not the issue.
Yeah, thank you, Mr. Chetrat. I can see you on the screen. The moment you feel that it's time, you just raise your hand. I will stop.
No.
Otherwise, all the people will become captive audience and victims.
No. Captivated audiences are only once you call the students that you will get the certificate or the lecture. But here we are, everybody is a welcome participant, rather they are sharing it on the Facebook, etc. So it rather shows that, speaks volume of your popularity amongst the bar as well as the bench.
Thank you. I'm beholden. Let me try to wrap it up so that there wouldn't be any inconvenience to anybody. Now let me come to the concepts of presidential application of law. See, traditionally, let's take many a time we have seen Chief Justice Holt, the definition as we have come across in our decisions. The reason of a resolution is more to be considered than the resolution itself. This is the conventional application of precedent. This is what to this day we believe. He said that in Cage versus Action, the reason of a resolution is more to be considered than the resolution itself. Then let me quote Lord Mansfield. He says, the reason and spirit of cases make law, not the letter of particular precedent. That was in Fisher versus Prince. But let me think of the modern alternative view. Sometimes there may be no rule of law set forth or enunciated by the court, but still a case can be a precedent. In this context, I may quote Professor Oliphant. He says, what the judge does and not what he says that matters. According to him, the ratio of a case is what the court has done in response to the stimuli of the facts of a case before it, not the judge's opinion. And now finally, I'll come to Professor Goodhart. He wrote an article in 1935, and that's available online. It runs into about 35 pages. Please, anybody interested, please download and read. You don't need to read a 1,000-page book on precedents if you read this professor's article. It's a torchbearer when it comes to the intellectual application of this principle. He says, discovering the conclusion from the material facts on which that conclusion is based is illogical and must lead to arbitrary and unsound results. Now, let me demonstrate how it happens. Let me assume the logic in reasoning is unsound. The analysis of prior cases is wrong. The statement of the historical background or a fact is demonstrably incorrect, but still the judgment remains a precedent. That means a proposition of law may be false or suspect, but if it gets ensconced in any case as its ratio, it remains precedentially protected. Now let me illustrate that with one specific instance. You have heard about the doctrine of res extra commercial. And that was for the first time applied in India in 1957 by Chief Justice Das's bench in State of Bombay versus RMD Chamber Bugwal. Kindly remember that concerns the commercial or business activity in immoral or noxious substances. They were rendered constitutional outcasts. You know, this principle were borrowed from Justice Harlan in Mugler versus Kansas. I'll tell the difference between the American application of law and that of Indian. In American Bill of Rights, those amendments, there are no inbuilt or inherent restrictions incorporated. So American Supreme Court has invented this doctrine of police power, and this res extra commercium is one aspect of police power, and that has applied. The Indian courts, I say with trepidation and also with humility and respect, Supreme Court has repeatedly, benches of varied strengths, held that res extra commercium is there to persist and holds the field with unabated vigor and strength. So it binds me. But academically, to discuss how law applies, how scholars view them, only that academic point of view, I'm explaining this one, not in defiance of a precedent that binds me, because we'll have this intellectual freedom in a seminar. You know, example of the meaning of seminar. Seminus means a seed, sprouting of ideas. So let the idea sprout, notwithstanding the precedent that binds us. Right. So here, what scholars have felt, under Article 19(2) to 6, already limitations have been built. So our importing police powers cannot be sustained, but that is the law that holds. So even when you have reservations about an application, a precedent binds. Nobody on earth, in the face of Article 141, say that doesn't apply because that offends the constitutional notion or my notion of law has to be applied. Now, a precedent can be applied either narrowly or widely. Let me see how the courts have applied. There's one case called Rex versus Fenton. You know, in this case, what has happened, a prisoner was working on a hillock as part of his labor. Then he saw a constable standing below. Deliberately, he loosened a large block of stone and let it roll down the mine. So that killed the constable. Then the court has held, if death ensues as a consequence of a wrongful act, an act which the party who commits it can neither justify nor excuse. You may kindly remember, neither justify nor excuse. It is not an accidental death, but manslaughter. So here, the preposition has been broadly applied. Once a person has no justifiable excuse, then it amounts to manslaughter. Under identical circumstances, let's take another example of a case, Regina versus Franklin. In that case, again, it involved a prisoner. He was being transported. And when they were crossing River Thames, he deliberately threw from aboard the ship a box of refreshments overboard the sea, and a nearby swimmer got killed. Then the point was whether the first case, Rex versus Fenton, will apply. You know what the House of Lords has held in that one? We do not think Rex versus Fenton is binding upon us in the facts of this case. And therefore, the civil wrong against the refreshment stall keeper is immaterial to this charge of manslaughter. What I would like to underline here is, law can be applied, but the judge's view depends on whether it should have a broad proposition or a narrow proposition. Then, how should we read the facts? Let me tell you, to wrap it up in a sense, we cannot have a precedent divorced from the facts. Isolated facts can't form precedent, I accept it. But ratio decidendi, if at all you want to have it, it should be a happy combination of fact and the law as applied to the facts. That's why most of the scholars now prefer to call the case holding rather than the ratio decidendi. Ratio decidendi perhaps misleadingly says the reason of a decision. But reason isolated, a principle of law, cannot be applied across the board unless the same set of facts or analogous set of facts are present. That's why a more appropriate expression that we may have is the holding of the case. Now, suppose a case has facts A, B, and C. Facts A, B, and C. And there is a bench comprising 3 judges. All 3 judges decide with 3 independent judgments. So Judge A says point A or fact A is essential for this decision. Judge B says point B is essential. Judge C says point C is essential. In future cases, either A or B or C, if any of the facts is present, it becomes a ratio. Let me take another example. First judge takes fact A is essential. Second judge says fact C is essential. Third judge says again fact C is essential. Then what is the precedent? Only fact C is precedent, not fact A. So when it comes to any material fact, we need not look at the record whether there is a material fact. It is the judge who has decided, and what has appealed to him as the material fact, that alone matters. I will demonstrate that with one example so that I could close and have the discussion, which is more interesting, I believe. Suppose facts A, B, and C are there. The judge may have missed 1 or 2 facts, or may have disregarded otherwise which you feel as essential. So tomorrow when you apply, you should not think the record bears the fact, the judge may not have considered, but still unless that fact is taken, it is not a precedent. I'm afraid that approach may not be right. I'll just demonstrate. You know, once a woman sued a person for breach of contract or breach of promise of marrying, when that man made that promise, he was an inmate in a jail. Common law indicates an inmate in a jail serving a sentence cannot enter into a binding contract. But the defense could not bring, or the defendants could not bring this point to the court's notice. Only at the final stage before the House of Lords, they are pleaded, but the court rejected, saying that that was not brought to the notice of the court at the earliest point in time. In the next case, if the other party brings that at the very beginning, then the first ratio will not apply. We cannot argue that since that's been disregarded there, that should also be disregarded here. The same way, you have to read. Most of the times we have been hard pressed for time. We rush through Google, go to some site, get a decision, and come to the court and say that this aptly applies. My friends, though it's quite academic and sounds quite hackneyed, sort of clichétic, I would like to say, unless we read the judgment in its entirety and appreciate the facts and the law that's been applied to the facts, what's been omitted, what's been taken as essential, then only the ratio emerges. So unless you zero in on that ratio, it's difficult to hold that this is the ratio. And now let me come to finally, there's been a lot of conflict, a lot of uncertainty in the minds of judges, especially at the district level. Most of the times, even in High Court, we face cases quoted or cited across the bench from either side, which are sometimes conflicting. So suppose there are 2 dividend bench decisions of either Supreme Court or High Court, and they are diametrically opposite. My friends, which one do you think that binds a judge before whom it's been cited? I take it for granted that the judge is bound by the precedent and the judgments have been cited, but they've been by the co-equal benches, yet they are diametrically opposite. Some people say the later decision prevails. Some people say the former decision prevails. Some people say the decision which accords more on facts, which has more reasoning contained in it. There's been any number of theories on this one. And At least half a dozen high courts, full benches of those high courts, have given conflicting judgments on this aspect. Eventually, about a couple of years ago, Supreme Court has clinched that issue by holding that the farmer decision prevails. The decision that's been rendered in ignorance of the farmer decision has become per incurium. That's why when it's being decided and how logical it has been is of no consequence. That's how it's being decided. And I do appreciate this precedent is the lifeblood of any practicing advocate. And perhaps it is a very good servant to aid you in your research, in your presentation, to underline a point, but it's going to be a very bad master. You know, most of the times, as I practiced in Mafuzal courts, the moment a client comes to us to narrate the facts of his case, our mind races to find a matching case law for his case. And we zero in on, we pick out from our pigeonhole, this is the case, he's been talking about accords well on facts. So whatever he says, we try to mold the entire case in that perspective. But when it gets into the witness box, that's not his version, it's our version. It's meant to serve the precedent that we have had in mind. So he frizzles out in the evidence. That's why, and also, as the saying goes, style is eternal, fashion is ephemeral, it changes. So the principles live forever. Let's have the command over the principles of law. And the precedents are apt to change, prone to change. That's why they could serve the purpose, but they're not the entire thing. The common law, it's been all with vigor, it applies to us. The precedent, it rules, but we have to tame it the way we can. Thank you. Mr. Chetrat, can we open the discussion?
Before we start the question session, one thing I would just like to inform you that on this platform, we are pleased to have Honorable Justice Maushmi Bhattacharya.
Yes.
We had requested her to pitch in few words before we take the Q&A session. And number two, I would just like to say that we were not at all the captive audience. We were all captivated participants. We were just mesmerized the way you summed up. And the fact that everything has been taken in a very seemingly manner is also testified from the fact that once you don't have more questions coming on the chat box, it shows that you have lucidly explained everything. So we have got very few questions that only demonstrate the fact that the speaker is speaking of volumes because people are not leaving the platform, they are captivated. And number two, they are not asking questions. It means that any doubts which were hovering in their minds, just like dark clouds, they have been dispelled and there's only sunshine in their minds. I will just ask Justice Maushmi Bhattacharya to pitch in few words.
Certainly.
That would be it.
Thank you very much, Justice Naidu. It feels strange to address you as Justice Naidu because Justice Naidu happens to be not only a friend, but a dear friend, but an inspiration to me at many levels. Thank you very much for a most enthralling talk. I literally braved the rain and the hail and the lightning. We are actually going through the Amphan cyclone right now to hear you. I mean, nothing could have stopped me from hearing you, even with the inclement weather. What I really appreciated about the talk was how it flowed from the history of the courts in England, the history of Anglo-Saxon jurisprudence, the 1066 Norman Conquest, and you know how the king became the repository of requests of parties who wanted to have an equitable dispensation of justice, and to very topical aspects of what we face on the bench on a daily basis. That is the hard debate of what should be followed and what may not be followed, and even eschewing a path of adventurism. I myself have faced this dilemma many a time, and it's really kind of, I'm lucky that I heard you talk about that aspect of it. Apart from covering other related issues on the various forms of stopping orders, super injunctions, very interesting new concepts. India is kind of waking up to, Indian courts are waking up to these concepts, and particularly with the with the technology really going out of hand in terms of speed. So thank you very much, Justice Naidu. I really think that this was a very, very important topic to address, particularly with regard to common law principles and precedents, because not only is that useful for judges, but also for the litigants and for the lawyers as to how a court, or what would be the approach of a court to address that issue. So I really enjoyed the talk, and on a very personal level, Justice Naidu, congrats and thank you very much for enlightening me on very many aspects. Thank you.
Thank you very much, Masha. Thank you very much.
Thank you, ma'am. It was a pleasure hearing you. We were also pleased to inform that Justice Maushmi Bhattacharya has also consented. She will be also giving us another day of sunshine of thoughts, which would only make us happy during this lockdown period. And thank you, ma'am, for all this. So we are just taking the Q&A.
For which Justice Naidu is entirely responsible, of course.
No, but once I was sharing with Justice Naidu yesterday evening itself. He said that you talk to her. She's a very good orator. I said that I've always read that birds of same flock fly together. So once you are knowledgeable, it's obvious that Justice Bhattacharya has to be of that caliber. And be that as it may, once we read on the Google, etc., we find your judgments are itself path-breaking. The judgments of wide spectrum, one coming from Bombay High Court, and one from the Calcutta High Court, shows both the metro places are quite lucky enough to have judges like both of you, who would just, as we say, the flavor of the judgments, which are palatable to everyone, to be cherished in the legal minds.
Thank you very much, Vikas. Thank you, but I think now the spotlight should be entirely on Justice Naidu.
Yes, sir. Yes, ma'am. Thank you. Hritika Sharma. Sir, is there any disadvantage of precedents, according to you?
Well, precedent is essential if it's a prop. But if it's your backbone, I believe that one day you may fail. Have it as an aid, but not as a master.
Thank you, sir. Vishal Devgan. If there is a conflict between a precedent and a statute law, which should prevail, and can precedent overcome the codified law?
Very simply put, never. But the question is, when it comes to the interpretation of statute law, that interpretation in turn becomes the precedent. That's why sometimes the judges face the allegation that they make the law. They overturn the law in the name of interpretation. And that's why at times precedent trumps. You take the example of Section 23 of Senior Citizens Protection Act. It says that if somebody gives the property or settles the property on his children with the condition they should be maintained, then they could seek for a declaration that's been void in the face of their not looking after their parents or whatever the elders. But courts have taken what you call a beneficial view of that legislation. They have said that even when it's not being contained in the deed, such stipulation, it should be read into. This is where the conflict comes. Statute may have intended one, the interpretation has gone for that one. So the conflict usually is not there. If at all it is there in the technical sense, the statute must prevail.
Thank you, sir. What is the significance of, this is by Sumiti Jain, he's a professor in the Patiala College. What is the significance of obiter dicta as a precedent?
Well, obiter dicta cannot be precedent. And it perhaps may have persuasive value. Suppose a judge renders judgment on fact A. In that, he also incidentally refers to, had it been otherwise, this would have followed. That can never be the ratio. That can never be the part of holding. but it's only an alternative thought of the judge, which will have persuasive value, but I don't think it will have any binding value.
Saloni Gautam, when we talk about judicial precedents, then instantly we remember the Maneka Gandhi case where the judiciary started taking suo motu approaches, but due to the approach of the difference of the procedure established by law and due process has been removed. What can be the future way and how will the removal of difference go to affect the future interpretation?
Well, the question is very much loaded. Could it be paraphrased? Some sort of,
yes,
what is
yes.
the focus on that question?
Yes. When we talk about the judicial precedents, then instantly we remember the Maneka Gandhi case where judiciary started taking suo motu approaches. But due to this approach between the procedure established by law and due process of law has been removed. What is your take on it?
Well, it takes a bit of an explanation. Let me tell you, if you think of Indian dispensation of justice from 1950 onwards, you take any landmark judgment, there the petitioner has never got the relief. Beginning from, you take this Keswananda Bharati, even Maneka Gandhi, in all those cases, principles have been laid down. And there is one interesting article. You know what happened when it comes to Maneka Gandhi? Somebody's passport was impounded, prevented from going abroad. The question was whether that amounted to deprivation of their fundamental rights. And then the matter was heard before the court. Vacation intervened. Then the judges have prepared their judgments running into hundreds of pages. When the court opened, the government has accepted and agreed that we will once again issue notice and then hear the party and rule on it. It's not my view. One scholar has said, you take the example of Marbury versus Madison of 1803 American Supreme Court judgment, Chief Justice Marshall. Then the third president of America was, what's his name? The American Declaration author, and also a cousin of Chief Justice Marshall, Thomas Jefferson. He was the president. They would not see eye to eye. And the Supreme Court was struggling to exist. So he ruled everything in favor of or against the government, but still he refused to enforce that one in the name of lack of jurisdiction. Once the common sense indicates a court lacks jurisdiction, then there is no question of giving any directions. That is the wisdom of Chief Justice Marshall. He seized upon the opportunity. A weak court, if he wanted his judgment to be implemented, the president, powerful president, would refuse. So he laid down the law, but avoided the confrontation. And the scholar, when it comes to Maneka Gandhi case, in an article writes, saying that in the wake of or in the throes of emergency, there's been a lot of what you call praying for blood or one family getting vilified, etc. So they wanted to declare the law, but still they don't want to give the fruits. That's what they've said. There, perhaps the due process has come back once again. And in fact, it is the second phase of constitutional interpretation. Whenever you talk about Indian constitution, you may have to talk pre-Maneka Gandhi and post-Maneka Gandhi. And judicial interpretation is an ongoing process. As the new situations emerge, the courts come out with new relief.
Yes.
That's why I don't think any judgment has a final word on any development or any doctrine of law or any aspect of law. It's only one phase. Maneka Gandhi is only one phase. Yes, please.
Before we proceed, another interesting facet is Honorable Mr. Justice Nagamatu, who is former judge of the Madras High Court. He has joined us. Just few words. Justice Nagamatu, just a few words for Honorable Justice Naidu.
Chamber.
Sir, probably is on. Ritika Sharma, do judges make law judicial precedents, or what is your take?
We have always been apologetic about this aspect. we feel shy of admitting the fact that we make law, but it's an inevitable corollary. If precedent is law, and it is law by any reckoning, yes, judges do make law, but that law never trumps the statute law. It only fills the gaps. It makes things move, the society on its wheels.
Krishna Chandra Sahu. During sometimes we have observed that even if we are citing a judgment of a same coordinate bench of other high court, but the courts concerned ignore it. That is the judgment of other high court. It is not applicable. You only cite this court's judgment. What is your take on that? Whether
they are right. They are right. The binding precedent, as we have held, when it comes to Supreme Court, it binds across the nation, High Court within its jurisdiction, and certainly when it comes to the doctrine of comity, other High Court judgments can be quoted, though they are not binding. They'll have persuasive value. Either judicial discipline or proprietary demands, instead of summarily rejecting or not entertaining them, we could as well have a look at it. And if at all we have felt persuaded, yes, we can have a word on it, or else we can mention that it doesn't apply. But sometimes when a plethora of precedents has been cited, a profusion of them, judges may not take them into account, because otherwise that runs into a very laborious process of adjudicating on that aspect. Technically, there's nothing wrong, but considering and then ruling on it is a wiser one.
Justice Nagamatu probably is there. Justice Nagamatu, we are just unmuting you.
Yes, sir. Good evening. Good evening.
Sir, could you show your video? We have been.
Good evening, Mr. Naidu, my dear brother.
Good evening, brother.
Oh, it was really a very good session. So there is nothing new for me, because I have heard you on several occasions on several topics. So it is like a homecoming for me. So really, I was enthralled to hear you, and people were really made us captives, as somebody said. It was a really fantastic lecture. And I got one small query that I want to place it before you, and you may answer that. Whether any order made under Article 142 could be used as precedent in future.
Well, the judicial thinking on that is, it cannot be a precedent, because that's confined to the facts of that particular case to do complete justice. In fact, in one occasion, when a bench of the Supreme Court has found conflicting views, rather a cleavage of judicial opinion among the co-equal benches, that's been referred to a three-judge bench. And three-judge bench has ruled, since those decisions were rendered under 142, that's why it may not be reckoned as a conflicting one. It's been confined to the facts of that to do complete justice, so it did not be. That's why, strictly speaking, I don't think it can be a precedent. It's my view.
I fully endorse your view, but what is happening actually is otherwise. So very recently, you know, that in matrimonial matters on the ground that the marriage is irretrievably broken, divorce is granted by the Supreme Court in excess of power under 142.
Yes.
This order is later on cited as though it is a precedent, and even the Supreme Court at times, relying on that and treating the same as a precedent, grant divorce. So strictly treating the same as a precedent.
Brother, you have already crossed the judicial bridge. I am on the bridge, so I'll be a bit careful.
Correct. Absolutely correct. I am free to speak. I regained my freedom. Thank you, brother. Thank you. God bless you. God bless you. And I thank the organizer also, Mr. Vikas. Thank you.
Sir, pleasure is all ours. And I'm just feeling that Justice Naidu is just like a magnet, that he's drawing everybody towards him. That is why we call it a drawing room, but we will say this Zoom platform is acting like a drawing room, that everybody is being attracted, judges from all corners. So last question we are taking: why High Court and Supreme Courts are called as constitutional courts and not the district courts?
Very well. Good question indeed.
That is by Ganesh Bhatt.
Yes. The regular municipal courts, they come up under a statute. And when it comes to the constitutional courts, first, their establishment has been referred to in the Constitution, and they come from the sovereign power of the state. Even the democratic state still holds the sovereign power. These courts are judicature courts, and they've been established by a royal edict or a constitutional edict. That's why this distinction is there. One is a statute made, the other one is constitution made.
Thank you. It has been explained very nicely. So we will not be taking any questions, but just a 5 minutes wrap off as we do it in a different way. So the session, as we said, that we were all attached. We couldn't just think of moving here and there, despite the fact that you have carried issues, historical background, other issues, precedents. It has been fascinating. One take, how do you, like you said that when your client comes to your office, immediately your mind goes, what could be the judicial precedent? And that is way as to how we connect to ourselves. What is your take for a young lawyer or for any other lawyer? What is your take, how he should read about it, how he has to maintain the balance between the cases which he has to read tomorrow and prepare tomorrow? Let's assume he has to do drafting, he has to prepare the case. And how does he take other issues at the same time? How does he maintain the balance?
Whenever I talk about the art of advocacy, I always tell young advocates, the best part of advocacy is the art of listening. Be an attentive listener to your client, because your client is the master of the facts. And faithfully record the facts as narrated by your clients. Don't be innovative or imaginative on the facts count. Then, when you draft, you have to be really careful. And I suggest to the young advocates to read a book, something like Unconnected to Our Profession, Atul Gavani's. There is one Dr. Atul Gavani. His book is there. That's Checklist Manifesto. Checklist Manifesto. It teaches how we can be attentive. Otherwise, what is obvious, we tend to miss them. Most of the times when you stand before the court, Mr. Counsel, have you pleaded about that one? Well, pretty sure that we have pleaded, but to our horror, when we go to the pleadings, we find it missing because it's quite obvious we have missed it. So be an attentive listener and present the facts in a methodical manner. And then only when it comes to the crux, when you're arguing to support your point of view as a prop to buttress your case, have the presidential advantage. Don't have the president as the bellwether or as a guiding factor. It should follow you rather than it should lead you. We wouldn't have landmark judgments if everybody has been stuck with the concept of decided cases or precedents. If we've been depending again and again on precedents, where's the question of heretical thinking, thinking in the new way, out of the box thinking, and having new trends in law? Yes.
So how do you feel that a lawyer should be, what is your take? One should continuously read, or and how does he improve his tools of wisdom, tools of application of mind? Like the lockdown has also taught us that how we have to go with the virtual courtrooms. How do we connect? Another format is maybe before the lockdown, it wouldn't have been easy for people to connect it on the virtual platforms to hear. And sessions like today, we are having 3 judges on the platform from different corners and connecting through this.
Yes, indeed.
So what is your take that what the lawyer should do to enhance his tools of knowledge?
Yes, I believe reading makes the law. There's no substitute to that one. When I began my practice, I made it a point. I chose one journal, law journal. I started reading one particular journal cover to cover. The advantage with that is when you read a textbook or on a statute, you'll have abstract principles of law extracted. But when you read law reports, you'll have those abstract principles applied to the fact scenario. It's something like reading a storybook. So have the habit of faithfully reading one law journal at least, and also develop your soft skills. Soft skills could be your linguistic command, or your knowledge of technology, or your knowledge about the general reading, because law is the conglomeration of various aspects. We need to be jack of all trades. We need not be master of anything. We need to be jack of all trades. And I believe legal profession is a very strange profession. An engineer, he learns, then he stops, he practices whatever his profession. Nobody is going to question him whether he's right or wrong. So is the doctor. Trial and error is his profession. But a lawyer always faces a battle every day. He stands on his feet, he thinks on his feet, he argues an opponent ready to pounce on him. The moment he makes a mistake, he is exposed. That's why an advocate always is like a soldier standing on a battlefield. The sharpest weapons he should have, otherwise he'll perish. Those sharpest weapons are his learning, his inclination to look forward to every source of learning. The learning includes his soft skills as well.
So what is your take? How should one improve the soft skills also?
Well, nowadays, you take the technology, you have had everything. In fact, you have got more than you could chew. It's profusion, a plethora. That's why, say, suppose if you want to articulate yourself, there have been any number of TED Talks which will show you how to deliver. And if you want to improve your skills of drafting, there have been any number of resources that will teach you. You take any aspect of advocacy, you've got one source to learn. Earlier, a junior would be spending a decade or more under a senior before he could break out, because he had no independent means of learning. Now, from day one, you've had at your exposure, sitting here, you can see Harvard lecturers delivering their lectures in the classroom. You have the comfort of sitting in your house and watching them. So is the case with Oxford and everywhere. The best of the material has been at your disposal. It's only your choice to choose and to apply.
Sir, I am reminded, like you said, the soft skills and the practice. I am reminded just in the Mahabharata, it was asked to Bhim that how could you eat when there is so much darkness, you are not able to see the food, etc. Then Bhim just said, that was in Hindi, abhyas or abhyas, that is practice and practice.
Yes.
So according to you, the practice should be there.
Indeed.
And according to what I have gathered from you, it says that for a professional, one should have the knowledge of 3 Ds. That is drafting, deliberations, and debates. That is one way to move forward. Sir, and before we part, I was just Googling and seeing that you have been able to, you speak on every aspect beyond law also. Like, I'm not talking on beyond law platform, but otherwise also on different platforms you are speaking on beyond law. So how do you get the time and how do you maintain that balance of reading within the law, beyond law, and delivering outside the law and within the law itself?
I take it as a compliment, even if it's not true, because it makes me happy.
No, it is as true as we say that ice floats on the water.
I always tell, sometimes your advantage turns out to be your strength. I'm incapable of doing anything else except reading, and that's come to my advantage.
I just wish that everybody could have that blessing. It's a blissful blessing. So thank you. It was a fantastic session. We have amongst us Assistant Professor Radhe. He will propose a formal vote of thanks. Before the words cannot just express the gratitude. The way you have summarized all issues, and I'm quite sacrosanct that those who have participated in the session and those who are watching on Facebook Live, or they will continue to watch the YouTube channel on our YouTube channel, that is Beyond Law CLC. This one of the sessions would be most sought after because the way it has taught the law of precedents would be a precedent to be learned by the lawyers and the professionals and the judicial setup itself. And it also shows the volume that you have been teaching you had taught in the Andhra Judicial Academy. I understand the students who have taught, who are judicial officers, would be delivering the judgments, which are itself, which would be liable to be upheld in the high courts and the Supreme Court, because the judicial officers, once trained by people like you, obviously the judgments would be very clear, very lucid, and elaborate. Over to you, Professor Radhe.
Thank you.
Thank you, sir. And a good evening to all of you. Sir, completely agreeing with Seshadri Madam. highly obliged to you, sir. Very well narrated and is encapsulated the judicial precedent with from the common law, obiter dicta, stare disease, and each and every aspect of the judicial precedent, which is very relevant to know each and every student of the law, either he beginner or he like just very learned person. So, sir, I am very thankful to you to encapsulate all the things in a 1 hour. That is the very important thing for me, that you your approach and balancing the subject from past to present and future. And I request to spare some times again in that platform during the lockdown, that is before the 31st May. And thank you, because sir, also to giving opportunity to me to thank to all of you. Sir, once again, thank you very much, sir.
Thank you very much.
Professor Adhiram, could you just substantiate where you have been teaching? Because large number of people in the platform do not know where you're teaching.
I am an assistant professor from Ahmedabad, Vivekanand College of Law, affiliated to Gujarat University.
So it again shows that people from the Gujarat are also there. So people from wide spectrum are there. So thank you. It has been a pleasure. And tomorrow we have a session on prosecution under the economic laws and their interplay. Do join us. We are having Honorable Mr. Justice Jitendra Chauhan from Punjab and Haryana High Court, Shri P.K. Malhotra, who is the former Union Law Secretary, Dr. R.N. Dash, who has been the former acting chairman of PMLA, and Mr. Amit Khemka, who specializes in that. I'm quite sure that the unlocking of these aspects by such dignitaries would again be a treat for the ears as well as to the mind. And that will help you to improve your knowledge in all aspects. Thank you, everyone. Stay connected, stay blessed, and stay healthy.
Thank you very much.
And tomorrow it's at 4:30 rather than 6 o'clock.